everyone. So I did have a moment to thank all our supporting councils and our partners, which I will again thank at the very end. We can't thank you enough because what you have done by your teamwork, not to mention our amazing gold sponsor of Gowling, they have made this possible. They make many of our other webinars possible, as I'll do all our sponsors. So thank you, all of you. So today we're going to have the webinar of the DIFC Data Protection Law webinar, and I'm actually just going to put this on right away to Tony because he is the man of the hour. So thank you so much, Tony. Good morning.
Good morning, Diana. Thank you for a very lovely introduction. And good morning, everybody. And thank you for taking time out of your day to join this seminar. I know that data protection is not always the most interesting of topics, but it is something at the moment that I'm sure you're all aware of has become a little bit of a focal point within the UAE, but also more regionally as well as internationally. So I think it's really important that there is a baseline understanding of what data protection frameworks look like in the region. And obviously the DIFC data protection law is the preeminent data protection law in the region that's most aligned to the GDPR in the EU. And so therefore it is a key legal framework that I think many of us, particularly those who are covered by the DIFC data protection law, need to comply with. I'm going to assume a certain level of understanding in relation to data protection principles generally. What I thought I'd just very quickly do is cover off about 5 definitions, which I haven't put a slide up for because I think that becomes too boring. But effectively, there are 5 key definitions that I think everybody needs to remember. The first one is what is a controller? And a controller is basically any person, either alone or jointly, who determines the purpose and the means of processing personal data. The second definition, which is key, is processor, and a processor is anyone who processes that personal data. Now, processing both under the DP law here and under the GDPR is an incredibly broad definition, and it includes transmission, retrieval, collection, storage, structuring, archiving, and any other variants of what you would normally think of as processing. So processing is very broad, and it's an activity that many of us, if not most of us, will engage in. Personal data is defined as any information which refers to an identified individual or an identifiable natural person. And a sub-processor is a processor, which I defined before, but that is appointed by another processor to then sub-process the personal data on behalf of the processor. So they're sort of the key concepts and definitions that I just want you to keep in mind because they're likely to apply to you and your business in relation to what it is. So what do we have? We have a new DIFC data protection law, which has built on the previous data protection law. It became effective on the 1st of July 2020, and it had a very short window of compliance. So unlike the GDPR, which had a longer window of compliance, what the Commissioner gave us here in the UAE is a compliance date of 1 October 2020, which effectively gave businesses 3 months to comply. Next slide, please, Hiba. Now, 3 months is a very short period of time, and like we advised in relation to the GDPR, it's important to keep calm and carry on and not let this necessarily impact your business immediately. However, having said that, if this DIFC or the new data protection law applies to you, it is important to look at your compliance at the moment and determine what compliance requirements you need to put in place. So while I'm happy for you to keep calm and carry on, I think it's very, very important and very, very timely, given that we've got less than 2 weeks in order for companies who are covered by the DIFC data protection law to actually fully comply. Next, Hiba, thank you. So what did we have? We had the old data protection law number 1 of 2007. It was a very comprehensive DP law for the UAE and this region, to be perfectly honest. But what's happened now is we've got the new data protection law here that's been introduced. And what that does, it repeals and replaces the old DP law. However, the old DP law obligations still remain. They have been enhanced, they've been made more robust, and they've been updated to pretty much align with more of the principles and the legal obligations that come from the GDPR, as well as the CCPA in California. So those principles have been borrowed quite heavily and built into the new DP law. What is also important to realise under the new DP law is it has additional rights, obligations and concepts that will apply to yourselves and your businesses if you become a controller or a processor and you process personal data. And they have provided enhanced rights and information to data subjects who are providing personal data to you and to your businesses. And the DIFC not only have they introduced the law, but they will also be building on their regulations in order to sort of supplement and give additional guidance in relation to what and how these DP laws will be interpreted by the Commissioner going forward. And they will be continually evolving by the DIFC authority over the course, I imagine, of the next 12 months, if not longer. Iba. So why does it really matter? So it matters firstly because there are fines of up to $100,000, and that is dependent, highly dependent on the nature of the breach and your involvement in the breach and the manner in which a company deals with or mitigates breach and the risks. Obviously, data is hugely valuable at the moment, and data is being monetized massively by every company, and that increases the risk not only to businesses but also to data subjects who are providing their personal data to companies. We're seeing consumer protection and data subject rights on the increase, and this is in order to minimise the risk to those individuals when they are engaging in providing personal data. And as I mentioned before, there is really a very heavy global and regional DP landscape that is changing fundamentally as a result of GDPR. And historically here, there hasn't been a huge amount of attention paid to data protection. And I genuinely believe that that is about to change, and the landscape and the obligations and the likelihood of enforcement is likely to change quite significantly in the next 12 to 24 months. And the final point of why it matters to you is market trust and resilience. If you want international investors, international collaborators, you want to build a profile within the region, having a benchmark of data protection frameworks and your ability to engender the trust of other parties and investors in your business, it's really key. So it matters for many, many reasons, and not just financial and not just risk. Next, Hiba. Why it matters to you is it's a slightly different version, but think of the stricter regulatory environment and your increased compliance issues and the ethics that are needed to apply to the business that you have. You need to mitigate your risks, and you need their reputational and financial risks, and they're also in order to avoid relatively hefty fines and also enforcement action. And I would say that one of the things that is likely to happen in the next year or two, but don't quote me on that, is that there is an expected or rumoured federal data protection law that is potentially going to come out. I understand that there is a draft out there, and that is likely to then apply to everybody and not just certain businesses who are covered by the DP law and the DIFC. And I think the message is very clear in relation to now and in the future. It's just don't be that company. Don't be the company that a commissioner makes an example of because you have breached data protection laws by ignoring them, because reputationally, I think it's a critical mistake. Iba? So does the DP apply to you? I think there are two sort of streams to this. One is if you're an incorporated company in the DIFC, the new DP law will apply to you, and it's regardless of where the processing actually takes place. So if you're incorporated in the DIFC, this new DP law will apply to you and your activities. Or if you are processing personal data as part of your business activities in the DIFC, you will be covered by the DIFC law. And they reference, the law references if you are processing as part of stable arrangements. And stable arrangements is not defined term. So it's likely to be a term that will be interpreted by the Commissioner and the DIFC as they look at enforcing these types of actions against companies. But I think it's safe to say that stable arrangements will mean arrangements or agreements that are notable for the particular business, are contracts that are material to companies, and are regular engagements that require the processing of personal data. And that certainly follows the sort of the European approach to interpreting what sort of stable arrangements are and how they would be interpreted here in the UAE. So what has really changed? I mean, we've had a fairly substantial DP law. The old law was fairly substantial. What's changed is a multitude of procedural issues and rights and obligations which protect data subjects and impose additional obligations on processors and controllers to ensure legitimacy, transparency, and the protection of personal data of data subjects. So what I've listed on the next couple of slides is some of the key changes that have come through in the new DP law. One of which is the introduction of high-risk processing activities and the requirements, which is a new set of obligations. And I will talk more about that in detail because it may well apply to quite a number of people on the call. Processors must provide much more information about the processing of their personal data to data subjects. So it's a much more extensive list of what you will need to provide to data subjects to give them clarity, understanding, and access to their personal data that you're processing. It gives additional clarity to those data subjects around the rights that they can exercise and that there are no sort of inhibitors in relation to, or discrimination in relation to exercising their rights against a processor or a controller. In certain circumstances, you will now need to appoint a data protection officer, which we'll go into later as well. And you also have the obligation of a record of processing activity annually to meet certain requirements. Next, please, Hiba. There's the additional requirements around the process of doing a data protection impact assessment statement, particularly in relation to high-risk processing activities, which I said I'll talk to you about further. They've introduced joint controllership, which was not a concept which was previously included in the old DP law, but has now been brought in. And I've got a couple of examples of that, particularly taking from the EU's interpretation of that, which might give some additional clarity as to how that applies. As I said, there are breach notification requirements that are required by individuals in the case of a breach. And there's also legally binding agreements or binding corporate rules, which companies will need to actually agree and enter into with other parties. And lastly, there are additional sort of changes in relation to, Hiba, can you just change the slide, please? Further changes in relation to cross-border transfers. So where you are transferring that personal data internationally, you would no longer need to apply to a commissioner for the permission to do so, but it is still subject to certain specifications and restrictions around the types of countries and the types of protections that are afforded in those destination countries where you are transferring personal data. And there is also a special categories of personal data definition, which was there previously, but now you no longer require the permission from the commissioner to process special categories of personal data. But there are, again, enhanced rights and obligations in relation to how that data can be processed. Because of the nature of that data and the sensitivity of that data, you as a processor or a controller of it will be subject to a much more significant threshold of responsibility in relation to that. So they are generally the key changes that have come out of the new DP law, and they do impose significant and additional obligations on controllers and processors and sub-processors in this sort of new world where data is just the new oil for everything. Hiba, next slide, please. I mentioned joint controllers being a new concept. It's an example really by the DIFCA of how they're looking to sort of enforce a sense of self-regulation by companies under the new DP law, so that you need to take a risk-based approach to your own assessment as to what you are doing in certain circumstances. And this is one example of that. So basically, joint controllers or joint controllership is where you've got two or more persons or parties that jointly determine the purpose and the means of processing the personal data. And in those certain circumstances, if you are and you assess yourselves to be joint controllers, the parties must enter into some legally binding written agreements that clearly set out and contractualize the responsibilities of both of those parties to ensure compliance with your respective obligations in relation to the personal data. The flexibility that this provides you as joint controllers is that you can actually, unlike in other circumstances where you're looking at sort of standard contractual clauses, you can agree indemnities, you can agree different liabilities, you can agree particular warranties. There's a whole range of sort of risk allocation and control mechanisms in a contract such as this between joint controllers, that the companies and the parties can agree themselves, which is not usually the case in relation to the standard contractual clauses. And secondly, you must make the elements of this written agreement available to any of the data subjects to enable them to exercise their rights. So if you're a joint controller of particular personal data and you have a database of your data subjects who have provided you that personal data, you must be able to make the terms of these agreements available with the key elements to enable these data subjects to take the relative action that they may require if there's any breach by you as a joint controller. And interestingly, the Commissioner, based on this sort of concept of self-regulation and joint control, they're able to apportion the fines if there are any breaches between the two. So examples of joint controllers are sort of few and far between really, but if we go on to the next slide, I've given you a couple of examples of what constitutes a joint controller. And really the issue comes down to where the controllers, as I said, can decide the purpose and the means of processing. And in this example where you've got a luxury car company and a fashion brand teaming up together, they're inviting the attendees to provide their names and addresses for the prize draw, but they don't use this personal data for any other purpose. You can see that these companies will be joint controllers of personal data because they are both responsible for the decisions around the purpose for which that personal data will be processed and the actual means of the processing. Another example of a similar example, which we're probably seeing much more of given the convergence of businesses currently. Heba, next slide, please. Particularly in industries like travel, you know, a travel agency, hotel chain, airline, jointly creating a common platform to provide the same deals and agree a share of the customer data, they will then be jointly determining the processing and they will be considered joint controllers. And I think going forward, given the convergence of technologies and convergence of industries and business sectors who are looking to sort of streamline processes and give new customer engagement to customers, we'll see a lot more examples of joint controllers. An example where it's not would be where we use the same example of a travel agent that sends personal data to airlines and hotels in the usual course of business to enable reservations to be made. But again, each entity is processing it for its own purposes and uses its own means in order to process that, to process the reservation, for example. So therefore, there's no joint controller involved in this. So they're just some simple examples of how joint controllership works, and the likelihood that there'll be more examples of this going forward, and there'll be more developments when it comes to the laws and guidelines as to how this will be applied going forward in the UAE, as well as actually in the EU. Heba, next slide, please. Another term of data protection laws generally, which is often seen as a very simplistic principle, is the principle of consent. And unsurprisingly, as with many legal concepts, consent is not always as simple as it would seem. Under the new data protection law, we have a much more robust and refined legal principle as to what constitutes consent. And here it reflects the fact that data subjects are key to the entire framework around data protection. And they are the ones who need to be in control of their ability to give and to take away consent. So consent under the new DP law needs to be several things. It needs to be explicit, and by explicit, it needs to be affirmed in a clear statement of words to you. It needs to be freely given by a data subject to you. They must have a genuine choice to not provide you with consent. So if there is any particular concern in relation to feeling pressured or a need or an obligation to give consent in order to get to another goal or to achieve another purpose, that is potentially considered not to be freely given. Consent needs to be specific. The consent must be in relation to that personal data that is to be processed. What you can't do is just bundle it all up and say you're requiring them to give consent for the use of it for marketing purposes, for medical purposes, for a whole range of other purposes. It has to be specific and identifiable and related to the particular purpose for which you are taking that personal data to be processed. And following on from that, it needs to be unambiguous. your obligation is to ensure that there is an ability for a data subject to give you a positive, clear affirmation and unambiguous consent. And this, again, goes to ensuring your compliance, but it also goes towards your ability to provide defensible positions in the event that there is a breach or in the event that there is any concern around the nature of consent that has been obtained by a data subject. So these are fairly high thresholds, and they reflect what has been incorporated into the GDPR also. Next slide, please, Eva. So what I would say around this is that there are some practical issues to consider in relation to consent. Yes, it's a seemingly simple concept, but it is actually not. And you will often find contractual terms and conditions with end users or contract terms and conditions with suppliers and supply chain, not necessarily setting out the relevant terms in relation to the required consents and obligations. So I think it's key to separate out consents from other legal terms and conditions or other contractual legal terms to make sure that it is clear and it is unambiguous and it is given expressly. Active opt-ins are very much the way that this can be achieved by making it unambiguous and clear and explicit. There are much more creative active opt-in ways now that I understand that using mobile phones where you can draw particular diagrams, particular pictures, or you can make particular statements to give your clear opt-in. And these, again, go towards a clear statement of consent that's being required by the particular data subject. The more granular the options that you give a data subject, the better for you and the better for the commissioner in the event that there is ever an assessment as to whether or not your consent is a valid consent. And as I mentioned previously, it is important to make sure that not only you make it easy for an express and explicit consent to be given, but you also make it similarly easy to withdraw and take that consent away if a data subject requires to do it. The DIFC have very good guidance on consent, and what's listed there is the link for that. So please feel free to visit that because it's actually a very sort of practical and good content guidance note on consent. Eva, next please. So in relation to consent, what you should do, I think initially what you should do is review your existing contracts and your existing consents in either your website terms and conditions or your app terms and conditions or your contract terms and conditions to determine whether they're adequate and that they comply with the new DP law requirements. Or also you could look to whether or not there are more appropriate legal grounds for you to rely on rather than consent. So it could be a legitimate interest, for example, where you are required to process personal data rather than consent, and that might give you a greater degree of flexibility and less likelihood of issues around securing consent. And so I would just say that at this point in time, when compliance is coming up on the 1st of October, it's probably not a bad idea to look at your consent mechanisms under your user engagement terms and conditions, for example, just to make sure that both your customers or your end users and or your staff and employees under your employment contracts are giving the required consents under the new DP law. Eva, next slide, please. So I mentioned earlier this new concept, which is not necessarily new under the GDPR, but it's new in the new DP law here under the DIFC. And it's referring to high-risk processing activities. And high-risk processing activities basically have three limbs, and it's not an and, it's an or. So it's either A or B or C or D. And I would basically say that this is, it's quite an interesting and innovative adoption of this new provision in the law because it's reflecting innovation and technology and how it's impacting on our ability to collect data and also the risks it raises for data subjects. So there are these particular four limbs here. So it applies when you are adopting new or different technologies or methods that create a materially increased risk to the security or rights of the data subject. So in those circumstances, new or different technologies, I think the best examples would be for example, blockchain or artificial intelligence platforms or algorithmic software that might be used by a particular business that is going to be adopted to process personal data. And we can all see that happening much more readily going forward, as it is now, in fact. And it is assessing that in view of whether or not that is likely to create a materially increased risk. And this is a sort of a factual assessment that will be made by the Commissioner in relation to whether or not that does have an impact on the security or the rights of a data subject, or makes it more difficult for a data subject to exercise its rights. But in the current environment where innovation is driving the monetization and access to data, this is something that I think quite a few businesses will be engaged in and will need to pay particular attention to, because I think it is this type of high-risk processing that will be a focus for the Commissioner going forward. It's also where there is a considerable amount of personal data that will be processed, and where that processing is likely to result in a high risk to the data subject due to the sensitivity. So for example, if you're a hospital or a medical clinic and you are collecting particular healthcare or biometric data about particular data subjects and you're processing a considerable amount of that, then this is what it would fall into. And again, a considerable amount, the DIFCA and the Commissioner are not likely to have a quantitative assessment of that. Again, it will be a factual assessment as to what will be a considerable amount in view of also the likelihood of a high risk to the data subject. Thirdly, another limb is the processing involving an systematic and extensive evaluation of personal aspects relating to individuals, and based on an automated processing mechanism that decisions or legal decisions will be based on and will have an effect on an individual. So a quick example of that might be car accidents being recorded, links and automated processes in relation to those car accidents linking to insurance companies, insurance brokers, who will then use an automated processing algorithmic software system that will look to identify your age bracket, the type of car you have, where you were driving, how you were driving, and determine based on those sets of data whether or not you're entitled to particular car insurance or whether you need to pay excessive premiums or otherwise. So that's just broadly an example of how that might be used. And the fourth point is high-risk processing activities. If you are processing a material amount of special category data, then you will be processing high-risk data, and you'll be subject to the new requirements in relation to this. So this is quite key as a new concept, and I think there will be a lot of businesses that will be subject to the new DP law that will in fact be engaged in high-risk processing activities and will need to not only do a self-assessment really in relation to these four limbs, but also will have other obligations that will flow from that. And we'll talk a little bit more about that in a few slides. Next slide, Hiba. So very broadly, some high-risk data examples: special category data, as I mentioned, so healthcare data, medical records, financial data, clearly, bank details, salary details, financial documentation, identity cards, passports, visas. There possibly location tracking data that would be used for GPS, used by ministries and other authorities in relation to tracking individuals. And also it can include data relating to other parties, third parties that have been gathered by, for example, me as a data subject in the course of my business. The next slide also shows a little bit more visually exactly the types of high-risk processing examples that you need to be aware of. So processing medical data, you know, if you're a medical practice, a wellness centre, a fitness centre, insurance broker, then you're likely to be engaged in high-risk processing activities. Similarly, banks, savings and investment houses, credit providers, or a payroll outsource service, you will also be engaged in high risk. And again, marketing businesses, data mining, consultancies who are doing data service analytics, which we're seeing a lot more of at the moment because of the monetization and the value of data to businesses. You know, and that in conjunction with artificial intelligence and algorithmic platforms, you know, we're seeing a lot more of these high-risk processing activities taking place in normal businesses and not just specific businesses. So I think it's very important that you're mindful and you do a little bit of a self-assessment in relation to whether or not your business and your processing activities will fall within one of those four limbs or literally sits within one of these sort of examples I've given on this slide. Eva, next slide, please. Now, the DIFC have done a really good job on their website of providing sort of high-level decision trees. I'm not going to go through these now, but if you're doing your self-assessment in relation to high-risk processing activities, the next 4 slides are literally just decision trees that have been developed by the DIFC to assist you in understanding whether or not it applies to you. So first talks about the method of processing, and I think that's fairly self-explanatory. And I'm more than happy for people to have access to these, but they are available on the DIFC website also, should you need them. Next slide, please, Eva. Again, will a considerable amount of processing be processed? There is a decision tree there, and will it result in a high risk to data subjects? That will assist you on whether you're high risk processing activity. Next slide, Hiba. Systematic and extensive evaluation, and again, another decision tree. You need to have a look at this and follow this to determine. And also remember that the Commissioner and the DIFC are also available to sort of consult with in relation to any confusion that relates to these things, because they're looking for this to incentivise compliance, to not punish people. So I would encourage anyone who is uncertain as to whether these activities are high risk to certainly try and consult with the DIFC if they need to. And finally, they give the next slide just is another decision tree in relation to a material amount of special category data, and that is fairly straightforward and self-explanatory. So please feel free to use those and visit the DIFC website. Not that I'm giving special plugs to DIFC at the moment, but it does sound like it. Next slide, please. A couple of other things that fall off whether you're doing high-risk processing activities. One is that you will be required to appoint a data protection officer. Now, this is a new obligation that's been introduced, and it's an obligation which I think will be of considerable concern to some entities because it comes at a cost. It requires certain requirements to be complied with. It requires certain talents and skills, and certainly those talents and skills may be short supply over here in the region. So you do need to appoint a DPO. It'll also require you to carry out annual assessment of your processing activities. Again, the DIFC provide good guidance in relation to what an annual assessment would require to contain, and it's not a cursory assessment either. It needs to be a detailed assessment of your processing activities and the data sets which you process. And if in fact the data is high risk data and you are doing high risk data, or the technology involved might elevate the risks to your data subjects, you will also need to do an impact assessment of your proposed processing operations and activities, and that will need to be provided to the Commissioner of the DIFCA in relation to how you process and what you process and the impact it will have. And they very helpfully give a sort of a red, amber, green analysis in an Excel spreadsheet also on the DIFC website that can assist you in doing an impact assessment statement. Next slide, please, Eva. So data protection officer, I think this is quite a key issue for people at the moment. Certainly companies that I've been speaking to recently are concerned about it because of the talent shortage and also the costs associated with. As I said, it is mandatory to have and appoint a data protection officer if you are a DIFC body or a court, or if you are engaged in the high risk processing activities. So just to ask yourself whether you fall into one of those categories which we've been talking about, whether or not you are using particular new methodologies or technologies or innovations to process that data that might increase the risk to data subjects, and do a self-assessment. And also there is the option as well to, if you are processing a significant amount of data, and let's face it, most businesses do actually hold a significant amount of data and process it, is that you should actually appoint, if not a DPO, have a responsible person or a responsible party in your business that can and will implement relevant procedures in relation to the protection of data, because it is only a matter of time before there is a federal data law, and the sooner that you are prepared in relation to these sorts of activities and these roles, the better I think it is for you, and the better it is for data subjects. I noticed there's some questions coming through, so I won't jump into them right at the moment now, but I'll try and do those at the end of the session if that's okay. And if we don't get to all of the questions, because there's quite a lot of them, we'll certainly answer them by email as well. So just so you know that I'm not ignoring you. Next slide, please, Hiba. So what are special categories of personal data? So it's probably not surprising to you that it's such things as racial or ethnic origin, religious or political beliefs, your political affiliations, criminal history and criminal records, and things like health and medical data. It doesn't, unlike other international DP frameworks, include sexual orientation and a variety of other things. But these special categories of data are sort of expressly set out in the definitions of the new DP law that you will need to be aware of if you are actually processing any of these special categories of personal data, because it will be subject to more enhanced and robust terms and conditions as to how, when, and what you need to do in relation to the processing of such data. Next slide, please. As I mentioned, there are enhanced requirements for special category data. One, obviously, which is the baseline for almost all processing, is getting explicit consent from a data subject. So if you are looking to process my medical history and you have my express and explicit consent to do so for a particular purpose, then you have satisfied the requirement. Also, where it is necessary for employment issues, such as organising and arranging visas and permit processing. It's also things such as exercising and defending legal claims. It can be used and processed in relation to those. Obviously, KYC and anti-money laundering is something that's on everybody's radar over here, along with cybersecurity. And I think that it's unsurprising that processing special category data in relation to these activities, or in fact following up on criminal offences, is legitimate. And also there are sort of other protections around sort of the, ensuring that there's no dishonesty or malpractice in relation to certain key activities in industries such like banking and insurance and investment. Again, to ensure a much more robust, sort of morally strong framework for the protection of consumers and data subjects. Next slide, please. So what I would say is, in relation to special category data, if you are one of those entities and you are using special category data, and you need assistance in that, I would certainly look to the relevant requirements as to what you need to be doing in relation to that special category data, and make sure that your contracts where you're requiring or obtaining your special category data give you express rights to do so in a certain way. And obviously we're able to assist you in relation to ensuring that any sort of contractual relationships with those end users can achieve that. The new DP law also has changes in relation to the transfer of personal data outside of the DIFC. Now the DIFC is quite obviously a niche free zone, but it is home to over 1,000 businesses. Many of those businesses are international operations with global subsidiaries and sister companies. And in that respect, they will be engaging in cross-border transfers of personal data because they will need to. Now, in those certain circumstances, there are requirements that need to be fulfilled. And under most of the data protection frameworks globally, particularly the GDPR, and now the new DP law here, there are certain countries which are identified as having adequate protection regimes where you can automatically send and transfer your data to. And they are a list of countries that are set out and that you can find. And there are no restrictions or qualifications in relation to transferring that personal data to those destination countries which have the adequate data protection in place. There are also one or more specific sectors within certain countries that are identified where cross-border transactions are able to be made. And there are international organisations, unsurprisingly, that have been deemed by the Commissioner in the DIFC to provide adequate level of protection, where obviously there are appropriate safeguards in place by these particular international organisations, or where there is a legitimate exclusion or derogation where they're able to transfer it because of a legitimate interest or because of national security or other particular exclusions that would apply to it. Again, There, I put the link at the bottom of the slide in relation to the adequate data protection jurisdictions for you if you would like to have a look at those and to see the countries that are listed in there. I'm not sure that many of them will be too much of a surprise to you. Next slide, please. I mentioned earlier the enhanced information is part of the requirements of the new DP law. And this is all around the holistic approach to protecting data subjects, protecting and having principles, robust principles in place to protect personal data of individuals. So it's quite an extensive list of information that if you're a controller or a processor that you are needing to provide to a data subject. So, you know, the list is here: who will receive their personal data, how long the personal data is being kept, why and the purpose for which you are collecting their personal data. Again, what security measures, or operational or otherwise, do you have in place to ensure that this personal data is being protected and if it's going to be shared abroad? And also, they have the right to ask you what steps you as a controller or a processor are taking in relation to complying with the new DP law obligations. And you are also, if you are required to have a data protection officer, you are also legally obliged to provide the contact details of the DPO to your data subject. So there is a much more sort of robust and protective framework as to what type of information and the details of information that you will need to provide to a data subject should they request it. Next slide, please, Hugo. This is also combined with what we see as enhanced data subject rights. And this aligns also more clearly with the requirements of the GDPR. And such rights are: a data subject has the right to withdraw their consent from you at any time. A data subject can request access to their personal data. They can request that you, as the controller of the personal data, rectify any errors or inaccuracy in that personal data. They also have the right to have their personal data erased from your systems, and I'll talk a little bit more about that and some of the complications that arise with that. They can object to the processing by you of their personal data, and they can enforce restrictions around what you can and can't do with it. They also, interestingly, have this right of data portability, where they can request that you give up the data that they have provided to you, and then they can provide it to another third-party controller. And interestingly, the new law also has a right that no data subject can be discriminated against by a controller in any way, shape or form in relation to the activities or the business they've engaged with you, simply by exercising any of their available rights under this law. So again, it's a very protective regime, and it significantly is aligning with other international DP regulations. Next slide, please, Heba. And again, following on from these enhanced rights, you have the ability, or I, as a data subject, or any data subject, has the ability to make a subject access request. And this is something that's sort of set fear in the hearts of DPOs in the UK and the EU, because it is not a simple process, particularly given the mountains of personal data that many businesses have. And particularly as a lot of that data is necessarily unstructured, it's not easy to access. But under the new DP law here, data subjects have the right to make a subject access request, and you are obliged within 1 month of the request being made to comply with that request and provide the information that is required. There are some exclusions around that take account of the difficulty and the technical issues that might be involved in extracting that personal data, the time-consuming nature of that, or the cost that might be associated with that. But that is initially the exclusions that might be looked at with some sort of grace here. But that changes, because I think if you are a sophisticated, large, multinational company who have organizations globally, you will be required to be able to do this. So they have to be in writing, and they have to be in an intelligible form. That's all that the law says here in the UAE under the DIFC. So the format is not prescribed, but it has to be in an intelligible form. You can consult with the DIFC if you would like to understand more about how to address a subject access request and what it should look like, and the key things you should look at. From my perspective and my experience, what I would say is have a robust subject access request process in your business as a first line of defense, because it will save you an awful lot of time. If you don't have a DPO, or if you have a DPO, or you have an HR person who is responsible for certain personal data, make sure they have the right tools and processes to enable and to facilitate them to take on these requests and appropriately address them. One of the advantages of having these processes in place gives you a sort of a defensible position in relation to decisions to not provide or to redact particular information. So it provides you a level of protection around what you are required to do for subject access requests. As I said, they need to be in an intelligible form. And what I've been advising quite a few companies, both here and in Europe, is that if you are likely to get many of these, and there has been an increase from employees in particular in relation to COVID circumstances, create a template for a subject access request. Yes, they will all be different, but you can create a baseline template and you can commoditize the work and effort that you put into them, because they do take time and effort. And particularly in relation to what I've said here, initial response letters to data subjects, letters to identify verification of the data subject, as well as sort of limiting and restricting or verifying the actual scope of the request, because sometimes the scope of a subject access request will be, I would like you to provide all personal data that you have in relation to me. Not particularly helpful, and it's worthwhile having these templates in place in order to sort of make it a streamlined process for you. Next slide, please, Eva. Again, international businesses operating in international jurisdictions, if you have templates, it's easy to localize those and have them translated into local languages. And therefore, once you do it once, it will require less effort for you going forward. Subject access requests are clearly, part of the problem is the technology. I mean, the technology has created the data and the mountains and mountains of data and the types of data that we have. But it also is now giving life to a whole range of new AI-based programs that are able to sort through the data to assist in relation to subject access requests. And there is the ability to redact information. So if there is particular information that is not related to the scope of a subject access request, or is particularly confidential and not related to the subject access request, you as the controller have the ability to redact that and take it out before you send it out. And as I said, you've got a month to respond from the date of the request being made by a subject, by a data subject. Next slide, please. So, the right of erasure, or what it's also called as the right to be forgotten, has been played out in both legal fields as well as with Google in a law case, a very significant law case about 4 years ago in relation to an individual who claimed that his personal data had not been fully erased from a particular website engine. And again, as you can appreciate, it's not an easy task. From an IT perspective, it's not an easy task, and it is a costly task for most businesses. But it is a right that has been included in the new DP law, but it is not an absolute right. So just because someone makes a request to have all of their data erased or they want to be forgotten, you don't necessarily have to do it. But they may raise this request in certain circumstances. So unsurprising, the list here, it's not that contentious, but where you no longer require that information for the original purpose that it was connected to, or if you're not relying on consent as a lawful basis for holding the data, and I withdraw my consent for you holding and processing that data, then you have a right to ask for it to be erased. And you must do it to comply with your legal obligations. But again, it is not an absolute right, and it is something that can be assessed by the DIFC in view of the way the EU has interpreted and looked at this right to be forgotten. So there are means and measures in place in relation to the complications and the technical issues that might arise in relation to this. But it is definitely something, given that data subjects and individuals are much more concerned about privacy and what companies are doing with their data and to whom it's being distributed, particularly in relation to data mining and marketing activities and the sale of personal data. I think we are going to see a lot more requests for the right to be forgotten by individuals as we go forward. Now, that may not be the case here in the UAE initially, but it's certainly on the rise in the EU, for example. Next slide, please. Very quickly, because I know I've been babbling on for quite a while. So there are fines. They're not GDPR fines, but they are fines to incentivize compliance. They are not intended by the DIFC to punish, but they are definitely there as a small stick to encourage you to get your compliance house in order. There are administrative fines, there are general fines, there are significant fines. It depends on the nature of the breach, whether it was knowing or inadvertent, the steps you've taken towards compliance, whether or not you have been open about how you have tried to mitigate the risks and or the damage to the data subject, and your level of cooperation with the authorities in relation to how you can minimise the damage caused by such a breach. And also, unsurprisingly, if you are a company who is repeatedly violating the law, then I think you're going to find that the DIFC aren't going to be particularly forgiving like other regulators around the world in relation to multiple breaches by the same company. And finally, just quickly, if we go to the next slide, this is just mechanisms, obvious mechanisms for you to sort of avoid fines. Compliance is obviously the first one. Appointing a DPO is also incredibly helpful to manage what is currently going to be a very difficult environment from a data protection perspective. And look at audits. And audits terrify people, and I understand why. But if we look at audits in a more soft respect of like a mapping exercise, data mapping exercise, and understanding what data you hold, what types of data you have, where that data sits, where it flows, does it flow outside of the company, is it transferred overseas? These are questions that you need to ask yourself if you are covered by this law. And obviously you will need to ask yourself these if a federal law comes into play in the next couple of years. It also increases awareness in the organisation across all departments. It provides you with an ability to be engaging with processes in your supply chain, particularly if you're engaging with a lot of suppliers or you're outsourcing business to other suppliers, because it's important that those suppliers who are processing your information are compliant with this law, because your customers will expect that to be the case. And also, given the timeliness of the need to comply by the 1st of October, for example, you know, do a mapping exercise, or get someone to do a mapping exercise, or work with you to do a mapping exercise, and prioritise particular areas of the business. I mean, if you are a medical organisation or a hospital, for example, or an insurance company, clearly you're going to have to prioritise particular areas of your business which contain particular types of information, whether they be special categories of data or just personal data. But I do think that there is a need to look at these things sensibly from a risk-based approach, given the time for compliance, and to start sort of looking at your risk areas and implementing the required changes that you need. And then in the next couple of slides, all I've set out here is, Hiba, if you could go to the next slide, please. Just some examples of what you might want or wish to do in relation to your road to compliance. And none of them are particularly surprising given the content we've just discussed, but I would say that it's probably timely that if you think, given what you've heard today, that you are covered by the new DP law, if you are processing information, personal data in the DIFC, or if you're, particularly if you're high risk, you're processing high risk data, then I think it's very, very timely that your business starts considering the obligations and the needs to comply and getting a compliance program in place. And a shameless plug on the last slide from me, Hiba, is we can help with that. And we can assist you with your data flow mapping and your legal compliance needs. We can help you with templates like privacy statements and a whole range of things that might need to be considered, some complex and some not very complex, that can be just addressed through some simple drafting techniques in your contracts or your end user website terms and conditions. And you know, we have template documentation as well for legally binding agreements, staff policies, privacy notices, those types of things. So there is a range of template documentation that we're also able to assist you with. So look, it's a lot of information to digest. I appreciate that there's quite a lot of content there, but I hope you find that interesting, and I hope you find it relevant to your business. And as I said, we're here to help. So if you've got any questions or you need any additional assistance going forward, then please, by all means, do contact us. And I think that's me done. And I am aware, Diana, that I've taken up pretty much the full hour.
But because it is such an well, pertinent and amazing topic to be covered, could we steal a few more minutes of your time and try to answer some of these questions? We've got Toya in here, obviously from Gowling, an amazing woman who has been kind enough to take a peek at some of the questions. And those other questions, like you said, we'll make sure you get them. Please, if you'd be so kind, put your email under your question again, so that we make sure we're answering the correct person. So, Toya, could you be so kind and chime in and maybe pick some of the questions that might have not have been covered by what Tony was talking about today? Could you do that?
Hi, Diana.
Hi.
Yeah, sure, I'd be happy to. So yeah, we do have quite a lot of questions. So let's just start with this one at the bottom. What is the definition of DIFC bodies? Is this incorporated entity in the DIFC? Does that mean DPO applies to all then?
So there is a definition of DIFC bodies, and it's very specific. And I'll read it out just so there's no confusion. So a DIFC body includes the Commissioner, the DIFC authority itself, the DFSA, DIFC courts, unsurprisingly, and any other person, body, office, registry, or tribunal established under the DIFC law or established on approval of the President or any other DIFC laws. So the DIFC bodies is a very specific defined term to, I would say, capture formal bodies constituted under either the DIFC law or other relevant laws that are set up in the DIFC to ensure that those bodies are compliant with the DIFC law, because clearly there will be quite a significant amount of personal data that's dealt with them. And does that mean that a DPO applies to them? Well, I would say that the DIFCA will definitely have a DPO because the DIFCA will, in and of itself, probably be conducting high-risk processing activities. As I said to you before, it's mandatory if you are processing high-risk data. So, you know, DIFC, DFSA, the courts, I imagine that there will be DPOs appointed in relation to those organisations. I see another question here on a similar topic, Toya, and I'll just jump in. High-risk processing is a material amount, when it talks about high-risk processing, is a material amount defined or guidance available. Look, the law is deliberately sort of silent in relation to sort of quantitative analyses of what constitutes a material amount. However, having said that, there is, on the DIFC website, there is a guidance note called High Risk Processing Activities, unsurprisingly, and it does in fact set out examples of what you might look at as being high risk, as well as what could be considered a material amount. But they talk about, I'm just quickly having a look just so I make sure I get it right, where they talk about, you know, a controller with several hundred staff, a controller with several thousand customer records, a business which collects, stores and analyzes personal data on behalf of its customers, you know, an aggregator platform or a referral platform. So I think it's incumbent in that self-assessment process to have a look at it and determine whether or not you think genuinely there is a considerable or a material amount of data that's being processed that would bring you within the confines of the obligations for high-risk processing.
Thanks, Tony. I see another one here, and it's asking, if we are GDPR compliant, does it mean that we are DIFC DP law compliant too?
Short answer, you're pretty much on your way to being compliant, yes. And that is great news if you are. And again, one of my comments in a previous webinar was, if you are based in the DIFC and you are an international company and you have compliance with the GDPR as a result of having other entities and other jurisdictions in your group companies, then chances are you are in a very, very good place. The issue then is, of course, that there might be some particular nuances under the new DP law here that might be slightly different, but I would say that if you are substantially or almost entirely compliant with GDPR, then you are in pretty good shape here under the new DP law.
Great, thanks, Tony. I think let's just choose perhaps one more because I'm conscious of the time.
Yep.
We have one that's asking about hiring a third-party agency to handle and process the personal data. Would the mechanisms in place within the third party be sufficient for the hiring company?
In other words, so he says, in other words, can we state the company's obligation is limited to the choice of the third party and assurances of implementation of legal requirements within the third party agency? Well, if you are, look, if you are, again, it's an assessment of whether you are a controller or a processor. So this question will, if you are a company who is outsourcing, for example, your personal data processing to a processor or a sub-processor, then what is required is to have relevant agreements in place between what we term as controller to processor or processor to processor terms and conditions. And if I am your end user or your customer, and I'm aware of the fact that you have outsourced your personal data processing to a third party, you will need to ensure that I'm aware of who that processor is and why they've got my information and for what purposes they're using it and if I've consented to it. And you will need to make sure that this third party that you are engaging is fully compliant with the requirements of the DPL. And that's where these controller to controller or controller to processor or processor to processor or sub-processor terms and conditions come in, because that gives you the ability to be able to have contractual relationships with this sort of chain of processing to ensure that there are no gaps or risks for you as the individual using the personal data, and no gaps by the processor or sub-processor in dealing with that information as an outsourced activity. So sorry, I quite quickly addressed those, but there might be a couple of others which I'm more than happy to deal with separately. But I think I've taken up much more time than I expected. So thank you for everybody's attention, and I'll hand back to Diana.
It was perfect. Thank you so much, Tony. Thank you, Toyin, for chiming in as well. We can't appreciate and say thank you more than what you guys are always there for us and giving us vital, pertinent information and actually making it very user-friendly. As you can see on the screen here, we've got Tony's email and whatnot, but do not worry, because as soon as you get your links to this recording there, we will be putting his email there on as well. And everyone at Gowling is very, very helpful. Again, Heather, can you please move the slide forward? We want to take this opportunity again to thank again all of our supporting partners. They are always amazing. It's such teamwork. We've got the Canadian Business Council of Abu Dhabi, the Canadian UAE Business Council, AmCham Dubai, the Australian Business Council of Dubai, the French Business Council of Dubai, and the New Zealand Business Council as well. And not to mention all the behind the scene teams. We've got obviously Toyin, who's behind the scene. Today she was up front, that's great. And we've got our obviously our gang at CBC Dubai here, always helpful. If you could just forward one more slide for us, Heba. Again, we want a special thanks to especially to our gold sponsor today, all our sponsors at Gowling. They make all our webinars possible. Today, they were really the man of the hour by stepping in and making, but all our sponsors are what makes all of our events and possibilities to have you businesses grow. So that is basically it. Thank you very much. I want to wish you all the best, and we're looking forward to see you soon. Bye, Tony. Bye,
Thanks,
Tony.
everybody. Bye.
Bye. Thank you to our participants. Great.
My
Have a nice
pleasure.
day. Bye-bye.
Bye, guys.
Bye.